Welcome to Advocacy Exchange, Navigating Texas Injury Law.
Welcome back to Advocacy Exchange, Navigating Texas Injury Law with Paul and Larry Littleton. Larry Littleton is the founder of Littleton Law Firm and a seasoned trial attorney who's been representing injured Texans since 1976. Paul Littleton is the firm's Director of Business Development and Operations, helping guide strategy, communication, and how cases are developed from the start. I'm Lisa Mosby, and today we're getting into what happens when fault isn't completely clear and whether someone can still recover if they may share some responsibility for the accident. Welcome back, Larry. Thank you so much for joining me again.
Hello, hello. Howdy, as we say in Texas.
Howdy. How do you approach situations where more than one person may share responsibility for an accident?
Well, Texas law is a comparative negligence state. What that simply means, you start off with 100%, and then you figure out if there's any percentages of liability or responsibility for the other parties as well. The person to recover as a plaintiff has to show a minimum of 51%. So if there isn't any other type of circumstances, if you were to go to trial and the jury comes back with 51%, then you would get 51% of your damages, 51% of your medical bills, 51% of your pain and suffering, whatever the damages the jury allocated. That is the base theory. The circumstances are that it can be divided up into two segments. One is confronting the liability issue is whether or not it's between multiple defendants or multiple plaintiffs. So those kinds of things can figure into and affect what happens in the outcome.
And then, Larry, what tends to shape how fault is divided in those cases?
The facts are the primary. The police report, what the officer thought after he did the investigation. Sometimes there are downloads from individual vehicles to determine speed and position. Some of the vehicles now have the ability not only to determine the speed just before an impact and at time of impact, but it also can determine if you were trying to move right or left at that moment of impact. So those can come into effect. There's also the testimony of the individual parties themselves. Many times in a police report, you will have a discrepancy between the drivers as to what happened first or what sequence was. Usually the one that affects the case most likely in the question of fault is the position of the vehicles after they come to rest. Whether or not a person entered an intersection and was almost completely out of the intersection when an accident occurred, even though no one can tell who had the red light or the yellow light at the time. So there's a whole myriad of facts and issues that may be in existence at the time. And particularly in cases of contested liability, that research, that investigation becomes critical.
And how does a person's share of fault begin to affect what they may be able to recover?
Well, if you have a situation where you represent a client, the plaintiff, and the plaintiff looks like he's 80% liable for the accident, there's not a good chance for recovery at all. It depends, however, more than just when they walk in the door. It means more than just looking at the police report. It means you still need to investigate. You still need to call as many people as you can that were involved in the accident and possibly witnesses. Circumstances that are addressed on the police report are not always correct, mainly because many times the individual plaintiff, the person that you're representing, was taken by ambulance to a hospital and never had an opportunity to be able to tell their story to the police officer. So it's again a question of determining who's at fault based on the facts. But again, if a large amount of negligence could be attributed or associated with your client, most likely the case would not move forward.
And then what kinds of information or evidence become the most important when fault is being disputed?
Well, the first thing that I look at in most of these accident cases, looking at the police report, at where the impact took place. For example, if the impact took place in the middle of an intersection, then most likely both parties had equal amount of time to react, and there was no one who was what we call in command of the intersection. But that may not be true. For example, you can have a situation where a client has crossed all 7 lanes of traffic and was about to exit the intersection when they were hit on the broadside on the passenger side, for example. Secondly, the position of the vehicles. If you have one vehicle that upon impact ends up turning around several times or flipping, and the other vehicle is almost stationary after impact, that's a good chance that that stationary vehicle was moving at a much greater speed than the other vehicle. So you have physics involved. The question of the mass and the speed of the vehicles. If the mass is almost equal and the speed is about equal, then there's not the reaction of the vehicles is pretty close to the same. But if one vehicle overreacts or goes in a different direction, that would probably mean that the other side is going at a high rate of speed. If that were so, then we would put out a letter to the defendant, the other insurance company, saying, look, we want to do a download. We want to look, see what the EDR says. And that EDR may say that at the time of impact, instead of doing 35 miles an hour, what's the speed limit, he was doing 65 miles an hour. And that would explain why my client's car flipped 3 times. So that could come into an effect of it. The other things is just talking to the witnesses. Sometimes the witnesses only see a segment of an accident. They don't see the total thing. They don't see all of it. They're kind of like if you imagine that they have a camera in their head, and at the time of the accident, when things happen, they may not be paying attention to the intersection at the time. They may only see what happens after the impact or what was said and discussed right after the impact. What did they say? Was there anybody who said it was their fault? Those kinds of things. It's a whole set of facts and information about the case. The police report is the start. Secondly, is to find out if there's any kind of EDR or information that we can get from electronic devices on the vehicles. And of course, the witnesses and photos. Those are all very important.
And then how do insurance companies respond when fault isn't clearly one-sided?
They just deny everything. They don't want to sit there and split up nothing. They don't want to listen to the facts. They said, no, there's no way we're insured. We're 100% liable. Okay. And sometimes it is clear that the vast majority of liability is on the defendant, and they will make an arbitrary picking a number. For example, we had a case in which the client was going through a parking lot, and an individual defendant gunned his vehicle because he was angry at his wife, I believe, and he pulls out real quick, hits the client. Well, they said that the client in this parking lot, they're only going to pay 60% of the damages. Well, where did 60% come from? Allstate doesn't come up with some crystal ball that tells them what the future is. They just arbitrarily selected that amount. So, if you're saying that the other side can be unreasonable, yes. Can they make assumptions that are not based on the facts? Yes. Is there something we can do? Yes, and that's fight with the facts, whatever the circumstances are. We don't assume anything. We try to prove everything.
So what changes in how a case is handled once there's disagreement about responsibility?
Well, in the initial stages of a case, they're all the same. You're looking for the facts, you're looking for the information to whatever you need to process for. But if there is a liability issue that pops up, then you may want to hire an investigator to be able to go and check the intersection. The intersection may have several businesses who have video cameras. The video cameras many times do not give a full picture of the intersection, but they can give you a kind of a snapshot of a certain part of the accident. Sometimes you can get, when these investigators go out there to these intersections, let's face it, most intersections has got a gas station somewhere. And so there's a likelihood for video. There's likelihood that the people who were working during that time are the same people on the same shift when the investigator goes out there and talks to them. And for the most part, people who see an accident are willing to testify. They're willing to tell you what they know and be able to give a slice of something. So you may have a bit of information from a video. The person who was working at the service station gives another slice, and you put all these things together. But that's kind of thing that you would do if you've got a denial of liability or there's a question of liability.
Larry, I know you've seen hundreds, if not thousands, of cases over the years. Can you walk us through a situation where fault was disputed, but the case still reached a strong outcome?
Oh, yes. A couple of years ago, we had a situation where it occurred in Beaumont, which is about 60 miles south of here. And it was on I-10. And I-10 is a major thoroughfare highway with a speed limit of 70 miles an hour. The client was driving in the far right-hand lane and taking care of her normal situation. She'd just come back with her child. They had done visiting grandma and grandma at the time, and they were deciding they were going to come home. It's about 10 o'clock at night, and as they're coming home, suddenly she feels a huge impact from the rear, and it pushes her into the forward direction almost to the point of hitting the guardrail on the other side. There were some injuries. They were taken to the hospital. There was all kinds of things going on at the time, but there were no witnesses. It was only the two vehicles. The vehicle that hit the client was an F-150, brand new. And that was important because the F-150, brand new vehicle, means it's got all of the download equipment. It has all the current EDR. Well, my client had a fairly new vehicle also, so we downloaded her vehicle. Well, it came to be a dispute because the driver of the F-150 said, "Oh, no, no. I was in that lane of traffic and she suddenly swerved in front of me and I couldn't stop and hit her." The first thing that we noticed about the circumstances was the damage to the rear of my client's vehicle was significant. The second part of it is what happened after the impact. It didn't make sense how my client's vehicle could end up so far down the freeway. The insurance company bought the story of their driver. They said, "No, we're not paying it. She changed lanes unsafely. And as a result, this is what happened on the collision." We filed a lawsuit because we had already pulled the information from the EDR and on our own client's vehicle, and it clearly showed she was in the same lane for a long period of time. There was no lane change. We also requested the EDR download from the defendant. The defendant refused. The defendant had his vehicle fixed. And on those, if you fix it in a certain way by pulling all the power, then the EDR will then reset. We had put him on notice, but he refused. At that point, the insurance company still refused. We filed a lawsuit. Then we had the difficulty in getting service. It turns out that this boy driving this vehicle decided he wanted to avoid service. But then we noticed on the title of the vehicle was the name of a female without the same last name, which probably means girlfriend. So we tracked the girlfriend down. That girlfriend was sitting in a small town in East Texas. So we redid our pleadings, sued her also, and we got a hold of her with the pleadings and service. And sure enough, all of a sudden, the boyfriend shows up and says, "Well, I was served." Gives it to his insurance company, and there we go. At that point, we were able to get the information from him in reference to his vehicle. Then when we got the information from them and we had it established that they had refused to give us the EDR, then we produced the evidence on the EDR we had. What it showed is not only that our client did not move right or left prior to impact, but our client's speed, which at that time was about 65 miles an hour, had increased almost to 85 miles an hour upon impact, which means that, given the law of physics, which don't ask me, that's the reason I hire experts to do that calculation, he estimated that the vehicle was moving about 90 miles an hour upon impact. Well, what that did pushed it into a question of not only ordinary negligence, but gross negligence. As soon as we produced the information, the insurance company folded and paid policy limits.
Yeah, that's a heck of a story. What challenges tend to come up when multiple parties are being considered at fault, getting all of those people to agree or to come forward? It's got to be difficult.
Generally speaking, in a claim situation, they rarely come forward. What happens is they start pointing fingers at each other and back and forth. And the first thing you know, you're trying to figure out who's negligent and who wasn't. In that situation, after you've done all your research, you've done talked to the witnesses, got all your information and requested EDRs from the various people, if it's an issue involved in it for speed or braking, then you file a lawsuit. And the reason you file a lawsuit fairly early in those kind of cases is because you don't know what they're going to say. What the adjuster tells you their insured says may not be the truth. Imagine that. But the point is that when you want to find out exactly what they're going to say, and you will find that there are discrepancies of who entered the intersection first, or if there was a lane change, or what their speed was, or the sequence of impacts. Many times you'll have a situation like this when you have a domino. Your client and my client is sitting here on number one, and there'll be 2, 3, 4, 5 cars behind, and there's a sequence of it, and the client says, look, I felt 3 impacts. And the guy behind there said, well, I felt 4 impacts. And of course, the last one is saying, I felt 3 impacts myself. So there's inconsistencies. What you have to do is do the depositions. The depositions will indicate, okay, tell me what happened at the time of the accident. Sometimes in domino situations, you will have a vehicle hit you from the rear, push you forward, and it acts kind of like a boomerang, pushing you backwards and then back into the vehicle again. That doesn't mean it was due to another vehicle. It just means there was a boomerang going on. Usually that's an indication if you've got the primary impact is severe and the secondary impact is more like a tap. That means it's a boomerang situation. Experts were able to tell all of this only after we have all the depositions done to make sure nobody changes their mind about the sequence and the number of impacts. That's the way you get that one done.
These are some great stories to help bring this image to life so that we have a better understanding. I think I want to leave it there for today, Larry. Thank you so much for guiding us through this. I have a complete visual picture of some of these examples to move forward, to make decisions, to make changes maybe to my insurance. Do you have any final thoughts for our audience that might be listening in wrapping this up today?
Yeah, it would be in a multiple accident, like a multiple defendant or multiple plaintiffs. It's important to get an attorney to represent you quickly just to be able to sort out the facts. But more than that is many times during these kinds of issues, the insurance company will call you up of the various providers and they'll ask them, look, we want to take a statement. Just tell me what happened. When you do that, you're committing yourself as to how the sequence occurred. And people don't remember everything. And as a result, if there's a discrepancy, suddenly they attach liability. And that can be devastating. So the point is that you need to consider a lawyer. You need to consider about whether you give a statement or not. Never give a statement until you have seen the police report to refresh your memory as to where everybody was going at the time. The point is you got to be careful because let's face it, not everybody tells the truth.
And that's it for today's episode of Advocacy Exchange, Navigating Texas Injury Law. If you've been injured or have questions about how fault may affect your case, the team at Littleton Law Firm is here to help you understand your options. Visit littletonlawfirm.com to learn more. Thanks for listening, and don't forget to leave a review, and come back next time. We'll see you there.
Take care. Bye-bye.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.